Item number 6, the Delta Watermaster, sitting in the front row looking serious but occasionally smiling, and the beneficiary of extraordinarily long quotation on Maven's blog or something of the Delta Watermaster, his role, his opinions, his analysis, and this very subject, the report you gave to the board, a couple of weeks ago.
I'll have to look at that. For the record, my name is Craig Wilson, the state's Delta Watermaster. It's funny, I got to your meeting agenda about 20 minutes ago and was walking in, and people were just rapidly leaving the building. I didn't know I had that much influence on people. I guess I know how to clear a room.
You do have influence on people, but I think they were leaving for other reasons.
I understand. I'm here today to present the latest in a series of reports that the Water Code requires that I submit to the State Water Resources Control Board and Delta Stewardship Council on various issues. I know you have a long agenda. I'll try to work through my PowerPoint presentation rapidly, but I think this is a serious topic that warrants your attention. By way of introduction to the topic, I think it's important to give a little bit of introduction about some of the events that led up to this whole issue of a Term 91, what I call a stored water bypass requirement. As you know, let's see if I remember how to advance this. To the left.
Our talented mechanical crew will come forward and...
Got it.
Got it. Okay.
As you probably are aware, the State Water Board was actually created in 1967 to merge two separate agencies, a Water Rights Board and a Water Quality Board, the idea being that the water quality issues affected water rights matters and vice versa. And nowhere is that more apparent than in the Delta. And I think the efforts of the Water Board over the years to deal with beneficial uses in the Delta is a perfect example of how those two functions have been merged. Since the 1970s, the Water Board has adopted a series of Bay Delta water quality control plans to protect beneficial uses in the Delta. And those Bay Delta plans contain water quality objectives, which are really more like standards, including flow standards. And they also contain implementation plans to how to achieve those standards. And this Term 91, which we'll talk about today, is basically an example of how the Water Board has used its water rights authority to implement some of these standards in the water quality control plan. So with that, I will get to the actual stored water bypass issue and authority. Term 91 is basically a subset of a introduced and well understood water rights principle, and the first bullet explains that principle. And rather than repeating it, I'll try to give an example to try to distill the stored water bypass requirements to its essence. In the spring, summer, and fall, as you know, there's a lot of stored water being moved around the state, and so any given water course is basically commingled with both natural and abandoned flow and stored water flow. And the natural water flow is subject to the state's water rights system, priorities, senior water right holders, et cetera. Whereas the stored water bypass situation, where people have actually spent sometimes billions of dollars to create a water project, stored it seasonally, and are releasing it later downstream for beneficial use, that water is not subject to the normal water rights situation, and those people that develop that supply have that right to the water, and even senior water right holders are not supposed to be diverting stored water, whereas they have the complete ability to do so for natural and abandoned flows. And I've listed various code sections and some court cases that kind of uphold this stored water bypass principle. I do want to mention two key water right principles that have an impact on stored water bypasses. The first is the rule of priority in the water rights system. And again, I want to impress upon people that the rule of priority completely and validly applies to natural and abandoned flows. And the rule against diverting stored water is not implicated for natural flows. And persons must bypass natural flows to senior people when they need it. So that is how that impacts that. And the other principle that has an impact on the stored water bypass issue are the area of origin laws. As you know, area of origin people have water rights and can establish water rights to divert natural and abandoned flows, even if they are junior to the projects and other people outside of the area of origin. It's sort of a flipping of priorities. And regarding stored water, area of origin still has a role because to the extent that stored water bypass requirements are applied, they are applied on a priority basis. And if people want to contract for stored water, they may have some sort of leg up in that process. That issue is kind of pending before the federal courts right now. It's kind of uncertain. But there is some legal support for an argument that the area of origin people have some type of priority to stored water flows.
So they're entitled to. So I own some property next to a stream, and I can build a reservoir that holds 1 million acre-feet of water, take it, and then sell it later.
Yeah, that's one aspect of it. I don't know how feasible that is to do, but if a area of origin type of entity wanted to create a project, come to the water board and seek an appropriate permit to do that, they may be able to go to the head of the line because they are located in an area of origin. Correct. So this kind of gets us to the actual application of Term 91 and how it works with water projects. As you know, there's two major water projects in the state, the state water project and the Central Valley project operated by the federal government. And these projects store large amounts of water in the winter and spring and then release water for transport south, either for their customers or to meet downstream needs and requirements of the water board. And when the Delta Water Quality Control Plans were adopted, they required that these projects meet certain water quality objectives, including flow requirements. And the effect of these water right conditions is to actually require the projects to release from storage or to curtail diversions when flow of water entering the Delta would otherwise be insufficient to meet some of these water quality standards. So what happened when those requirements were put on the projects, they started protesting subsequent water right applications wanting to protect their water supply. And this Term 91 was developed to kind of share the allocation of who was responsible for meeting these flow objectives. And Term 91 basically specifies that certain permittees are prohibited from diverting stored water, which is being released by the major projects to meet water quality standards or other in-basin requirements. And these named permittees, they're basically post-1965 permittees and licensees, could not divert project water when natural flows entering the Delta are insufficient to meet water quality standards, and the projects are releasing water to meet the standards. When it was originally adopted, it was intended to be kind of an interim solution, but it has become kind of a long-term method of attempting to allocate the responsibility for meeting water quality standards in the Delta. Next, I'll turn a little bit about how the process of Term 91 works and the actual experience in 2012 to give you a feel for that. Basically, what happens in any given water year is that, well, first of all, I should point out only 120 permittees have Term 91 in it. It's basically permittees that are junior in water right priority to the projects. So those were the applications that were protested by the projects after the term was, after their obligation to meet water quality standards was imposed, and the water board decided to impose a stored water bypass requirement on those junior water right permittees and licensees. So basically what happens in any given water year is that the projects notify the water board when stored water is being released to meet water quality standards. And that can be early in the year or later in the year, depending on how much flows in the system. For instance, if the curtailments and restrictions apply from May through August, about 90 of these permittees and licensees are asked to curtail their water use. If it's been a wet year and the obligation to meet standards doesn't kick in until later in the year. It can be as few as 25 or 30 permittees. And there actually have been 3 years in the last decade that flows have been sufficient that none of these junior water right holders were required to curtail their water use. So what happens at after the notifications made by the projects, the State Water Board issues what's called a notice of curtailment to the 120 or less permittees that are subject in the given year. And then the permittees have to file a certification that they either ceased their diversion, curtailed it, had an alternative source, either through another water right they held, a riparian or a pre-1914 or more senior water right, or purchased water. And so that's the way they have to certify that they've met the terms of the Term 91. And the board has sporadically gone out with certain compliance inspections to see whether people are actually abiding by the term. In 2012, the notification was not received regarding Term 91, its applicability till June of that year, and curtailment letters were sent to some 27 permittees in July. The curtailment period was in the month of August. And eventually, compliance certifications were received from all 27 permittees that were subject to the term this year. There were some compliance checks done, some field work, office reviews, and no instance of violation was found. Everybody that was subject to the curtailment requirement complied with it as far as we could tell.
Mr. Wilson, refresh my memory.